Good afternoon.
Good afternoon.
May it please Your Honor, Carolyn Murphy representing the state of California. The Ninth Circuit Court of Appeals overstepped its authority when, in a 2016 case, it overruled the 2008 State Court of California's case, which denied the habeas petition filed by the defendant, Kevin Jones. Under the Anti-Terrorism and Effective Death Penalty Act of 1996, the California Court of Appeals can only grant relief if the rejection of Jones's right to silence claim was contrary to or involved in unreasonable application of the clearly established federal law at the time of the court's proceedings. The federal court does not have the right to make an independent decision based on the facts that are present at the time of their trial. Instead, there must be unreasonable application of the Supreme Court's holding at the time of the state court's trial. This highly deferential standard of evaluation gives the benefit of the doubt to the state court. In Harrington v. Richter of 2011, it is stated that when reanalyzing a state court's decision, the federal court is obligated to use the law of the time of the state court's decision.
So, counsel, let me interrupt you there because it seems to me that since 1996, it has been clearly established authority that all custodial interrogation has to cease if the defendant, and this is what this court said in Miranda, indicates in any manner during the course of an interrogation that he does not wish to be questioned any further. And so isn't this sufficiently established case law to guide the trial court here?
That might be what the other side is going to argue, but in fact there's a difference between clear and unambiguous invocation of the right to remain silent. In this case, a lot of what the other side will argue is that the right to counsel and the laws that have led up to this point are to be applied to the right to silence claim that Jones has, which has brought us here today. So the point being that an unambiguous invocation would have been different than a clear invocation. And the clear invocation, which is what was established which was called into question in the initial interrogation, led there to be an ambiguity to the situation, which led the police officers to continue with their investigation due to the fact that it had not been clear. So that leads me to that in our current case, the California State of Appeals made its decision in 2008 based on the understanding that the right to counsel and the right to remain silent had very different standards of invocation. It was not until 2010, which is 2 years after the State Court of Appeal, after the State Court affirmed the trial court's judgment, that the laws regarding the right to counsel were applied to the right to remain silent. These two standards were merged in Burgess v. Tompkins, where the court concluded that the right to remain silent must be invoked unambiguously, like that of the right to counsel. But Miranda, prior to the Tompkins decision, everything that had led up to the 2008 case was very limited. There was not a lot of established federal law that dictated what to do in the case of an unambiguous right to remain silent.
What about the Smith decision from 1984? And the Ninth Circuit relied heavily on that decision in overturning the trial court's judgment.
In 1984, the Smith decision did say that after an unambiguous statement asking for counsel had been made, there was to be no further interrogation and that you couldn't retroactively apply doubt to that invocation that was made. This, however, was only deemed relevant in 2010 in the Burgess v. Tompkins case, which then said that that ambiguity and the lack thereof, all the rules that led up to it, could be applied to the 2008 ruling. So in the Smith case as well, it comes into question when it gets a little confusing when you start to realize that the ambiguity came. In the Smith case, ambiguity was never the problem, it was what happens afterwards. But in this case, the ambiguity is the question of whether or not the actual statement was made. So in accordance with EDPA, the fact that the 2010 case made by the 2010 case of Tompkins Burgess v. Tompkins was made relevant is incorrect and unlawful because of EDPA. This court's lawful obligation is to overturn that ruling and return it to the state court's decision.
Thank you.
Good afternoon, Your Honor.
Good afternoon.
May it please the court, Catherine Pollock for the respondent, Kevin Jones. The Ninth Circuit Court of Appeals correctly found that Kevin Jones Jr.'s constitutional rights were violated when the incriminating statements he made following his unambiguous invocation of his Fifth Amendment rights were used against him in trial. During a custodial interrogation on the night of August 15th, Jones told detectives, "I don't want to talk no more, ma'am." These incriminating statements, the incriminating statements that he made following this invocation of his Fifth Amendment right to silence should be considered inadmissible by the court for two reasons. First, according to Miranda law and the court's decision in Smith versus Illinois in 1984, it is evident that questioning should have immediately ceased following his invocation of his Fifth Amendment right, and that context cannot be used to cast ambiguity over the transcript of that evening. Second, according to the court's findings in Schneckloff versus Bustamante in 1973, a case about voluntariness, this case about voluntariness proves that the incriminating statements he made were involuntary. So first, to address the clarity of Jones's statements, he told the detectives, "I don't want to talk no more, ma'am." According to Miranda law, if the individual indicates in any manner at any time prior to or during questioning that he wishes to remain silent, that the interrogation must cease.
So let me interrupt you, counsel, and ask, there was a colloquy about whether we can look to Smith in this instance, whether it's fair to do so, given that we didn't have the guidance that we could do so until, or at least the trial court didn't have that guidance until after it rendered its decision. But Smith, even if we do decide that it's fair to apply, says that we can look at the statements and the nuance in context preceding an alleged invocation. And if we do that here, can't we glean from the record, or isn't it reasonable at a minimum to glean from the record that the statement was ambiguous?
No, because the statements that we only can look at that one statement. They're looking at that state that he clearly invoked his right to silence, and we can't look beyond that statement or even before that statement, because it is in that statement that he invoked his right to silence, and so interrogation should have immediately ceased. So continuing, looking at first the clarity of, so Miranda draws a bright line for us, and Jones invoked his right to silence. The detective said, "I understand," and the interrogation should have ceased there. So continuing on, the coercive nature of the interrogation and the totality of Jones's, so the second point, the coercive nature of the interrogation and the totality of the circumstances must be considered based on the findings of the court in Schneckloff versus Bustamante. And this case found that voluntariness must be considered in the context of many factors. So in this case, we must look at the respondent, his youth. He was only 19 years old. His lack of education, he had only just finished technical school. The length of his detention, he was kept for several hours, and he was in isolation during the entirety of that time. And the use of physical punishment, he was very cold, and he told the detectives that over and over again. And
what is the actual standard? I mean, I understand you said we need to look to the totality of the circumstances, but aren't police officers allowed to sort of play on a suspect's ignorance and fear and the uncertainties. So there is some gray area there, isn't there?
Yes, but this case defines what is considered coercive and what is considered okay for the police officers, the extent of how coercive the police officers can be. And in this case, his will is overborne and his capacity for self-determination is damaged by the police officers' interrogation. And the police officers clearly understood this and understood his invocation of his rights, but Jones did not understand this. And so the interrogation should have ceased immediately.
Thank you. Thank you, Counsel.
Thank you.
All right, thank you both.